So Bonnie Yates is joining us. She is our guest today and most Mondays, whenever we can get her. She is a special education attorney, and we're so thrilled that she's here. I'm on a split screen. I like that. But she is joining us thanks to the Tollner Law Firm. So Bonnie, happy President's Day.
President, heavy wool sweater and wool hat and fur-lined boots, and it's like 25 degrees outside. And that's life in New York.
You look like you're doing what was the movie that they played this weekend?
Anna from the North.
Well, but I was going to say, what's the big Omar Sharif movie when they're in Russia?
Dr. Zhivago.
Yes, you look like you're in Dr. Zhivago. That's what it is.
My grandparents were from there, Okay, Shannon, so we have questions from last week that you're going to read. I'm going to answer, but first we're going to tell everybody, thank you, Tollner Law Office, for letting me do this. We are a 7-attorney firm based in San Jose, California, with offices in Los Angeles and Orange counties. We are fiercely committed to your children's educational rights, and the more we can help you understand about them, the more comfortable you will be in an incredibly uncomfortable process that nobody would go through voluntarily and probably would volunteer to have all their teeth pulled without anesthesia instead. You can find us on the web. If you want a free consultation, you can fill out the forms. And if you're in Northern or Southern California or Arizona, we can help you. If you need an attorney and you're not in those states, then look at COPA.net, COPAA.net. They're a great organization. They have an attorney directory. They're having their annual conference in March, all online. So if you want to check that out, check out their annual conference. There's going to be some good stuff they're doing there. We're not giving specific legal advice. We're giving general advice. A lot of you come to us with very specific problems, and we're happy to talk about them on the air, but it's not a substitute for having a conversation with an attorney that can really focus in on your specific district, your specific problem, and so on. So with that, we had a question that we left, question or two from last week that we need to finish, and so on.
And I don't know which question we left off on. So I think we left off on the one about OT, but tell me if I'm wrong.
What was the one before that?
The one I feel like the one before that we answered was about, should we postpone our IEP until we?
No, I said thumbs down on that.
Okay. And then, so the next one, and tell me if it sounds familiar to you. My son has ASD diagnosis. He is 5 and attending kindergarten online this year. We had completed our IEP before COVID, and he had speech and OT services. It has been a nightmare. It took forever for them to figure out how to do speech online, and they never really figured out the OT. Now they are making recommendations for the new IEP, and they are removing OT. Their rationale is that he did okay without it. Please tell me that this is as stupid as I think. Did we answer that one?
No.
Okay.
I mean, in general, it's very dangerous for a district to remove a service without doing an assessment to confirm that there's actually no need. So when they refuse like that to do an assessment, you can ask for an IEE. They may not grant it, but if they should have assessed an area of suspected disability and they didn't, that's a basis for requesting an IEE. If you file for due process, that will trigger stay put, and they will have to continue all his services. You may not be in a position to file for due process, but sometimes if you just write the district a letter and you tell them, hey, we're invoking stay put, our services should all stay the same, and we're going to go out and get an assessment for occupational therapy, and we're going to seek reimbursement from the district for that assessment, I think you might be able to stop the train before it's out of the station. I guess, it's funny reflecting on the last, 11 months of this, and each like quarter of the year has had themes, right? So the sort of the September to December, or like October to January theme which popped up with school districts telling parents they'd withdrawn their kids from the district when in fact they had actually been forced to place them elsewhere because of a dispute about FAPE and the district's failure to provide FAPE during school closure. But districts were trying this withdrawal thing to see if it sticks. Now that we're moving into what hopefully is a phase of where we're slowly coming back into the larger world, and schools are going to reopen, you're going to start hearing that, hey, you did okay without it, hey, you're fine without it. Apropos COPA, and my friend here, Barbara Ebenstein, who's a hearing officer and attorney in New York State, and a wonderful person and attorney. She told me a little story this morning when we were catching up, and it sort of indicates what should be going on. She said there are some good districts in New York. In one district, a man that I know, who's the special education director, asked the board for extra money. He said, I'm going to have to assess every one of these kids when they come back into the district after a year. And I don't want to use teachers or school psychologists to do the testing because I want them to be able to be there 100% for the students. So I need money to get outside assessments by private professionals so I can figure out where the kids are at so I can serve them. Okay? That's what your team should have said.
Yes, but what was the response when this professional asked for more money? Did they give it to him?
I don't know. I think he got it.
Okay, well, that's the kind of school we want to be at, where professionals like that are working.
Well, guys, without like deep, wandering too deep into the pool of politics, New York State spends a lot more money on education than California does, and guess what? They have better programs.
Yeah, well, I mean, that just sort of follows, doesn't it?
Yep.
Well, okay, so for this parent, they can't just say you're not getting as you said, OT. So they got to ask for them to be evaluated.
Correct.
Is that the takeaway? Okay.
Yeah, and
So
I would be really aggressive. I'd say not only do we not agree with you, we think you owe us 11 months of compensatory education.
Well,
I
we have
want one session a week for every week that school is in session.
talk about phases of where we're at. A lot of our questions that are where we're at right now are people in one way or another, whether they know the word or not, are asking, how do I get compensatory education? So hold that thought, we're going to get there. In fact, the next question: we are starting the process of asking for comp ed this summer. Can you outline the steps of how we pursue this? My hope is to get them to pay for a one-to-one tutor for the summer. My fear is that they will offer a summer school in person with masks. My son is in 4th grade. He has missed so much academically this year, and I'm concerned that a summer of masks will not come close to getting him caught up.
Well, here's another hard truth on Monday. There are certain things in this life, there are many things in this life that are unfair. One thing that's unfair is that in order to win some of these cases, or to be successful in some of these situations, you may have to give up your idea that the school district is going to provide it because you ask for it. You may instead need to create a record by having an IEP and showing why the district offering won't work. And you may need to pay for the tutor yourself and sue the district for reimbursement. They're not going to look. They're most of them are running at a budget deficit of at least 10%, and they are going to say no to everything right now because of that. So you're going to have to double down if you think something is necessary. Well, that's a little bit like princessy of me to say that, because it's not always within somebody's capability to pay for something and then show that it worked and worked better than what the district thought, and then bring them to heel. But in a lot of these situations, that's the only way you're going to get it. I had this come up recently with a mom who is a wonderful mom and a former teacher, and she's been fighting really hard to get her school district to give her son a research-based reading program. He has autism and he's got a reading comprehension problem. He's very bright. And she said to me, look, I can't afford to take him out of public school. I can't afford to pay $150 an hour 3 times a week for ed therapy. What am I going to do? And I said, go meet with this educational therapist, see if she'll train you on the programs, you buy the books and you start doing them with your son. Because that's the only thing I can think of that'll work. What you really should do is take him out of public school and put him in a private school for SLD. But if you're telling me that's not going to happen, we're just banging our head against the wall with the district. You know, the district's, yeah, this is helpful, we're doing it, it's working well, and all the research that we've read says it doesn't, and even if it were, it's supposed to be 5 times a week and he's getting it 2 times a week. Tough choices, guys.
Yeah. Yeah, it is tough to, but I appreciate you saying that, Bonnie, because I think a lot of times people think, well, if I go to a lawyer, they're going to tell me that the only answer is this litigious route. And that sometimes it's about, just looking at it. We were talking earlier about creating a manifesto. And if what's most important is that your child learn what they're going to learn, you got to make the decision. Am I going to fight the district for it and spend all my time doing that? Or am I going to learn how to teach it? So I appreciate you saying that. Okay, what are Bonnie's thoughts on having our kids repeat a year due to COVID? I feel like this year is a waste and wonder if a do-over isn't the best choice.
It might be a good choice. It would depend on a lot of different things that you haven't included in your email. If it's a great teacher, if the peer group is good. I mean, retention has been disfavored for a long time in special ed circles. And I think that's because the notion was if you conceded that a child needed to be retained, you were pretty much acknowledging that you hadn't offered FAPE and he hadn't made progress. For the first time during COVID, I've actually seen some schools agree to retention. I don't know enough facts about your case to know whether retention would be the best option, um, and what class he or she would be returning to. Is it general ed? Is it special ed? But retention is a possibility, and if you assess the situation and you don't think there's a better alternative, then I would certainly consider it seriously.
Okay.
It's an IEP team decision, by the way.
Okay. Last week you talked about prior written notice. If we get prior written notice and disagree with the decision, what are our options?
Well, I guess that would depend on what the prior written notice said. Um, but like I was thinking about my cases this morning, and it's funny, I have one case where I know they said the family withdrew their student, and I can't remember whether, it was in a letter or a prior written notice. I have to go find it. But if it is in a prior written notice, you can either respond to the prior written notice the way you'd respond to an IEP in writing, tell them why you disagree, or you can request another IEP meeting to, discuss whatever the issue is that you need to discuss. The purpose of prior written notice, in my mind, is sort of fairness and clarity. And prior written notice is supposed to be given every time the district agrees to or fails to do something with respect to the issues of eligibility, um, goals, services, and placement. Okay. So that pretty much, um, an assessment. So that pretty much covers it as far as when districts should be doing these PWNs. They don't do them nearly as often as they should. The districts that have their legal act more together do them more often in cases because they realize legally it protects them. So when you get a prior written notice from the district, you got to read it very carefully, and you got to look at what it is that they're saying, and you got to consider, like, why is it that they feel it's important to tell you this now? Um, Districts were supposed to send out a PWN when school closed, right, in March. Many of them never did it. Many of them did it months late. But that would be one example, right? They're changing the delivery of services to the student from face to face learning to a distance learning mode. That's considered to be a change, I guess, in placement or services, triggering the need for either an IEP or a prior written notice. But I get PWNs on all sorts of things, and I encourage parents to use them because parents frequently leave IEP meetings and they're understandably frustrated because they kind of got the runaround. They've asked an intelligent and fair question and they're just told no. And when somebody does that to you, and they patronize you like that, it makes me feel like I'm about 4 years old and you're talking down to me. And I don't allow myself to lose my cool anymore. I still find it internally irritating. But I think the way to handle it is to push back and say, you're not just allowed to say no to me. This is a process. You have to give me notice. I'm entitled to know what you believe the issue was, what your decision is, and what resources you relied on in making your decision. So if you think about it from a school district perspective, let's say you ask for an IE is a bad example. What would be a good example? Let's say you ask for a tutor at the IEP and the district says, no, I don't think it's necessary. And you say, well, I'd like to discuss that. And they say, well, our answer is no. The response to that is, please give me prior written notice. Then if they give you the prior written notice and you don't think it's complete enough, you can write them back and say, your prior written notice is incomplete for X, Y, or Z reason. Ultimately, a prior written notice becomes a piece of evidence in a due process, and you could have an allegation that says the district's February 15th prior written notice denied student a FAPE because, and then you talk about why it denied him a FAPE, just the way you would with an IEP.
So I'm going to ask a really beginner question. I'm
Oh,
not
you
going to
always
use,
qualify your questions. Your questions are so not beginner.
well, this one might be.
And even
When
if
you
they
get,
were a beginner, beginners'
okay.
questions are great questions.
So we get a lot of like communication from the school. Like you get an email this, you get an email that. Sometimes you get a letter that comes in the mail. When we get these prior written notice, does it look just like any other communication, or does it say this is prior written notice that we
It
are
should.
changing?
It should say it headline at the top,
Really?
prior written notice. Yeah. Mhm.
Okay. All right. Because
It should use the words. It should use the words prior written notice as well.
okay. So for the first, now I really, this was a relatively new concept to me like a year and a half ago when we started talking about prior written notice. And I got used to thinking, okay, we have the IEP, it's a legal document. But all the time schools act like it's not, like it's this fluid thing and they change things. And my new understanding as of a year and a half ago is that if they're not going to do what's in the document, they have to give you prior written notice for the fact that they're changing it. But I
Correct.
feel like this person is saying, okay, they sent me. So the example that I
You
can
can
think
give
of,
prior written notice verbally at an IEP. That's possible, but it has to conform to what I said. You have to give the reasons and what information you relied on.
but so then I think the question that this viewer is asking that I now have too is that if they give you prior written notice, and like, so I can think of for my son that we had written into the IEP that he had placement, and they agreed that it would be with a certain teacher. They almost never do that, but in this instance they did, that it would be with a certain teacher because he was going into a class that was a split. It was a 5-6 split, and they agreed that he was going to have placement in that class with a
Yeah.
specific teacher. Then the school started and they decided that they were going to disband the 5-6 and there wasn't going to be a 5-6 split, and they moved him. And and they told me
Was
that
he
they
in
were going to,
general ed?
yes, and they told me that they were going to move him, and so I would imagine that's prior written notice. But what happens when you don't agree? What's the recourse when even though they've given you prior written notice and
You
they're
can you can file for mediation. You can request a mediation only, or you can file for due process.
okay? So we do have recourse. They can't just, because otherwise it feels like, well, they can do the IEP meeting and then they can send the prior written notice and then we didn't get what we wanted anyway. So our recourse is mediation or due process. Okay, great.
Right. I mean, mediation only is something that doesn't involve going to due process. You have a settlement conference with the district. You're not, uh, you know, um, apparently represented by an attorney, which doesn't mean you can't consult with an attorney behind the scenes. But it'll be the district and you, and usually like a facilitator that they hire. So unfortunately, those people tend to claim to be neutral, but their paycheck is signed by the district. But that gives you an opportunity to sit down with them outside of an IEP meeting where they're more conscious about following procedure and, that it's being recorded, and at least see where they're coming from.
Okay.
But, there's nothing I'd like to see better than all of you filing for due process this year without attorneys and just jam up the system. And believe me, the deals will get better.
Well, that's a very interesting take on things.
Yeah.
I think
Yeah.
we need to do a class at some point, Bonnie, because the idea of filing due process, as I know you say it's
Next
easy, but
week, next Monday,
okay, let's do
10:20
it.
a.m. Okay.
Let's do it because I know you say it's easy peasy, but the idea of it makes me shake, and I'm sure it makes other people shake too. I'm like, I would need to know exactly how to do it before I threaten.
You know what?
So,
I mean, if I said it's easy, shame on me. Shame
oh,
on
well,
me. I should do a whole other show on the emotional experience of being a lawyer in these disputes. Maybe some people think they're fun. I think they're stressful. They cause a lot of anxiety for me. I've learned how to deal with it, kind of, sort of. But I don't want you to think anybody loves this.
okay. All right.
Maybe
Well,
I'm
that's
like,
helpful.
maybe I'm being too transparent. But like, if you like getting hit in the face with a crowbar, bring it on. I mean,
Okay. Well, I think that yeah, well, you seem so
why
confident
would
about it.
anybody ever like, why would anybody who's a human being ever like watching their clients be screwed over by a school district that is lying to them?
But I see you must have a higher tolerance for pain then because you decided to do this for a living, and to give back. I couldn't do it, Bonnie.
Oh,
It would
come
make
on, look what you're doing instead.
this is different. This is like
Look,
the pain point.
when the bars reopen, we can have this discussion between the two of us. But let's
All
do
right.
it next Monday. Let's talk
Okay.
about due process.
All right, next Monday, due process workshop. I'm going to let everybody know that we're doing that. Okay, we had one last question, and I really want to get to it because then we'll be clean docket, right?
Yeah,
And
and
this
I've got something at the hour, so
okay, all right. So we got like 2 minutes here. How can I get the school to pay for speech therapists outside of school? We've been getting our speech this year online, and it's not getting it done. She needs in person, and the school won't allow that.
insurance or pay for it yourself, give 10 business days notice and file for due process. If you can get the district to agree to do it with an outside provider, more power to you. You should ask, they'll say no, and then you should move on to the next level.
Okay, fabulous. Perfect timing. Bonnie, tell us again about Tolner Law Offices before you have to buzz off.
Tolner Law Offices is on the web. Shannon's nice enough to put it up every week. We'd love to hear from you. If you want a consultation and you're in the state of California or Arizona, go ahead and fill it out. And, please keep asking these questions. They're really grounding and important for me to see like where people are getting tripped up. It's helpful. So it's not, just a question of you give me the information and it helps you. It's you give me the information and it helps me. So I really appreciated the questions from the last two get-togethers because I think they're very telling. I think they tell us a lot.
Well, Bonnie, we appreciate you. We appreciate Tolner Law Offices. Thank you so much. And I know you got things to go to. Stay warm.
And that's not a problem. Thank you.
Take care. Bye bye. Thanks for watching Autism Live. If you found anything helpful in this video, please give us a like. In fact, make sure that you smash that subscribe button on YouTube and give us a like on Facebook. You can also follow us on Twitter and Instagram for important updates. And please download our free podcast wherever you get your podcasts. See you next time. Until then, give your kiddos a hug from me and one for you too. Bye-bye for now. To subscribe, click here. And if you'd like to check out some more of our videos, click here.